federal appeals court has issued a ruling that could dramatically change concealed carry laws around the country. By a vote of 7-4, the Ninth Circuit Court of Appeals in San Francisco upheld a California law that requires gun owners to show a good reason before they can get a license to carry a concealed handgun. So San Francisco had attempted to limit to some extent how many people are using concealed carry in public by having them say why it is they feel they need to carry a gun around wherever they go at all times. And there was challenges to that, and this ruling protects it. But they go a little bit farther than that. They say the protection of the Second Amendment, whatever the scope of that protection may be, which is an interesting turn of phrase by itself, simply does not extend to the carrying of concealed firearms in public by members of the general public. Because the Second Amendment does not protect in any degree the right to carry concealed firearms in public, any prohibition or restriction a state may choose to impose on concealed carry, including the requirement of good cause, however defined, is necessary, allowed by the amendment. Now, in terms of openly carrying, that's a slightly different thing, and they did not actually extend this to the question of openly carrying. They said that that question was not an issue in the case, which is true, but this is still big either way. I mean, they not only said that this San Francisco law can stay the way it is, this sort of small restriction, extra paperwork, and maybe cutting down the number a little bit, they're saying there's nothing in that amendment that protects your right to do that. And so theoretically, if a place simply wanted to make it totally illegal to do concealed carry in public, if this stands, then they would be able to make that illegal in a city or a state or nationally as well. Now, how did they come to this conclusion? Is this simply an activist judge who decided on his own to do this? Obviously, it's an appeals court, so there's going to be multiple people. But how did they come to this conclusion? Well, Thursday's majority opinion traced the rights of gun owners from medieval England to the founding of the United States and throughout the Civil War, finding that local laws almost universally prohibited carrying concealed firearms in public. In 1897, well after the adoption of the Second Amendment, the U.S. Supreme Court ruled that the right of the people to bear arms is not infringed by laws prohibiting the carrying of concealed weapons. And so the sorts of law that our courts drew on when we became a country allowed for stopping people from doing concealed carry in public, and the Supreme Court has already ruled on it, which I had actually not been familiar with. And so this is certainly interesting, and I know that it's interesting because the NRA and different media sites that are feel positively towards the NRA have gone absolutely crazy as a result of it, but they don't like this at all. They don't like the idea that their concealed carry rights could be taken away, their rights that they believe they had that apparently the Federal Appeals Court says they don't, and it is entirely possible that this will, of course, be appealed and then go all the way up to the Supreme Court. Now, right now, we have a basically balanced 4-4 Supreme Court on most issues. I honestly don't know if that will hold when it comes to gun rights. But imagine if Scalia had been here. It would be that much easier for this appeals court ruling to be struck down and San Francisco to be stopped from trying to have somewhat reasonable concealed carry policy. So we have a 4-4. Now, imagine if we had a 5-4 liberal majority on the Supreme Court. This would almost certainly be upheld. So it's another thing to bear in mind when thinking about who is going to end up choosing a Supreme Court justice. This is just one of many issues that is going to ride on that decision. But if you look at this, I mean, that's a pretty broad ruling to say, no, simply because you say it gives you that right, the Second Amendment, it doesn't actually give you that right. And that, at the end of the day, is really what this is all about. What does the Second Amendment actually mean? What rights does it actually guarantee? There are people in this country that think that it allows for everything, that no rights having to do in any way with guns can be put into place. No rights can be infringed on by laws that are put into place. There are people who literally, when you ask them, oh, do you think you should be able to have a tank or a rocket launcher? They do think that they should be able to have a tank or a rocket launcher, as stupid and crazy as that is to someone like me. There are people who think that literally you should only be able to have guns while serving on a militia, which is, I think, a very interesting position. And if you simply take the plain text that's in the Constitution, that does seem to have some evidence for it. But this is important because concealed carry in public is, in effect, quite dangerous. Lots of people, how many stories have you seen of Home Depot, somebody walking through with a gun and they blow their balls off? This happens a lot, that people simply want to have guns on them, and simply by those guns being around, there are going to be more accidents, more guns stolen, and more people accidentally shot that shouldn't have been. And I recently saw a tweet from someone, I'm not going to name who, that, oh, you think that gun-free zones or no-gun zones are going to stop a terrorist from coming in? Well, that must mean that you're an idiot. No, that means that you're an idiot, because of course nobody thinks that gun-free zones are going to do that. They want guns to not be there casually all of the time to stop thievery and accidents and all of that stuff. Stopping concealed carry furthers that same goal. I don't want people's balls being blown off in hardware stores. But, maybe I'm just a simple kind of guy.